Good morning, all. Today, let us try to see some of the innocuous clauses, or should I call them as tidbits, that don't look very sinister on the outside of it, but on a little bit of a deep dive, they can convey a much deeper meaning. Some of these clauses in the Finance Bill 2024, let us go and visit this. There is an insertion in section 28. Section 28 talks about what a business or profession, or what is a business income all about. The insertion is a clarificatory insertion which says that if any letting out or part letting out has been done of a house or residential house, then such an income will need to be treated as a house property income and not as a business income. One has to understand that under section 14 there is a schedular system of taxation is inherent in the law. It specifies 5 heads of income. Each of those incomes are watertight compartments, so that what is allowable as an expenditure and what is scoped in one particular head need not be scoped in the other head. This is the realm of it. Under house property taxation, renting of land and land appurtenant thereto is treated as house property income irrespective of the type of the assessee. This particular amendment which is being proposed, in the memorandum explaining the finance bill, it says that some of the individuals have been claiming this as business income. To prevent such a mischief, the same is being inserted on a clarificatory basis. Now, does it mean that other corporates and other people who are letting out property other than individuals, they can start claiming the same under business income? The drafting is so lax and loose that this is going to open a Pandora's box of litigation in the days to come. Having said that, there are landmark judgments under house property taxation. The East India Hotels case, or be it the Sultan Brothers Constitution Bench decision, and Raj Dadarkar case recently as well, which have held that the schedular system of schedular system of taxation for house property will need to be well respected, and what is relevant to house property will need to be offered under the income irrespective of the nature of the assessee. There are contrary verdicts, of course. Karanpura development, which was regarding mining rights by the Supreme Court, and Chennai Properties Investments case, which I think is a one-off per curiam one-off decision rendered per incurium. But the fact is this much: as long as the schedular system is there in the law, one has to respect it, and the same has to fall into house property income. Perhaps in the Finance Act, we might see some fine tinkering of the wording to make it into a watertight compartment. This is the first section that I have now discussed, arising out of the innocuous amendments in the Finance Bill. Going forward, Section 37(1) Explanation 3. I do not know what is so enamoring for the Ministry of Revenue with this section. Every recent budget has had one amendment or other in this section. Basically, this section prohibits any expenditure which is incurred for infraction of any law, be it in India and outside India, as an expenditure which is not an allowable spend under business or profession. Now, this budget is again bringing in with a clause which says any such notified law or such rules or circulars, etc., will also form within the ambit of the disallowance. Now, recently there has been the Uniform Code for Pharmaceutical Companies, UCMP 2024, which has been unleashed by the pharmaceutical industry under the Ministry of Chemicals, etc., wherein all pharmaceutical companies, etc., are obligated on a quarterly basis to declare of their compliance under the ethical practices proposed in the code. I do not know whether that will get notified, etc. Already this section 37(1) Explanation 3 is more or less has got morphed into a moral policing section from being a merely fiscal disallowance section. I think we need not be surprised if we get to see newer and newer additions being made in this. Having said that, the industry has been lobbying hard and fast on the removal or an amelioration of section 43B subclause H, where I think delayed payment to MSME enterprises is not an allowable expenditure if it is not paid within the time limits under the relevant provisions of the MSME Act. I do not know whether that will also get notified in the specific proposed amendment. The reason being, what is infraction of law is also applicable even for MSME enterprises. So people may need to bite this particular amendment with a little bit of a bitter pill in the coming days, as we do not know what are all going to be what are the items which are going to be enlisted and notified in this proposal. This is the second section. 47 subclause 47 talks about transactions which are not regarded as transfer, and 47 subclause 3 reads basically gifting, will, etc., which is done by any person is currently exempt under capital gains tax. Now the amendment is being proposed to limit this only to individuals and HUFs. Corporates can no longer gift, but under Transfer of Property Act, a corporate can very much gift. All that section 122 of the TOP Act requires is a donor, donee, a willingness to accept and a willingness to give, and no consideration for a gift to be valid. So going forward, gifting by a corporate will no longer be valid. This is, I think, there have been recent decisions in the IT which have disallowed gifting by a corporate since it was seen to be a subterfuge, ways and means adopted to evade taxes. Anyway, these are three provisions which are very important to understand because they look innocuously less violent on the outside, but they convey a much deeper meaning. We will see couple of more of such clauses also in the coming days. Thank you.